Good afternoon. Welcome to the regular meeting of the Board of Directors of Miami Sports and Exhibition Authority, August 22nd, 2017. It's 12:13 in the afternoon. We First we begin with a roll call by the Executive Director to determine if we have quorum.
Good afternoon. Mayor Tomas Regalado,
Here?
Commissioner Willie Gore,
Here.
Mrs. Karen Hardeman,
Present.
David Madison,
Present.
Eli Feinberg is absent, Rachel Ortner Frost is absent, Nathan Kirtland,
Present.
Ms. Catherine Moore,
Present.
Mr. James Cosell is absent, Rafael Cabrera,
Present.
Rudy Sablon,
Present.
Mr. Frank Veloso.
Here.
We do have a quorum.
Okay, thank you very much. So we have several discussion items. We have here the Director of Planning and Zoning, Senior Director Francisco Garcia. We have our Director of Building Department, Jose Camero. We have our zoning manager, David Msea, George Wison from the City Attorney's Office, and of course the public that it's invited to participate. One of the items on the agenda is a report on the heliport process and potential action by the board in case the board decides to take any action or move any resolution. So when do we start? So we have the City Attorney, Victoria Mendez, here. Thank you very much, Madam City Attorney. And so when do we have maybe, okay,
Yes.
the building, the building director will have a report for the board. If you can give him the microphone so it will be filmed.
Good afternoon, sir. The heliport Watson Island requires an exception process that was discussed on the last meeting. As of today, the application for the exception was submitted on July 13th, and the case was assigned a number. It's going before the PCAB, Planning Zoning Appeals Board, on September 20th. And right now, staff is reviewing the application to give a recommendation to the PCAB. Any questions?
Does the board have any questions on this matter? Go ahead.
If you could just briefly let us know why it requires an exception.
For that, I'm going to defer to the planning director,
Okay,
Francisco.
thank you.
No, my pleasure.
Thank you.
Good afternoon, everyone. Francisco Garcia, Planning and Zoning Director. The question was, why does the heliport proposal for development on Watson Island need an exception permit? The exception permit, I'll recap briefly, it's been mentioned before, is a special permit that requires a public hearing. And in this particular case, the board that is empowered to hear the case and potentially issue an approval or a denial is the Planning, Zoning, and Appeals Board. It requires an exception because just about every use in a civic institutional zoned land requires an exception. I'll explain briefly why that is. Land throughout the city that is zoned civic institutional or has a land use designation of government institutional, right, is land that is set aside for governmental uses or institutional uses, as the name implies. And these can take different sizes, different scales, different building types, depending on the use. So, for instance, uses anticipated or projected as part of this zoning designation are as varied as recreational or amenity projects, community centers, schools, churches, etc. And you can easily imagine that any of these can take different forms and different massing. And because this designation, the civic institutional zoning designation, is applied citywide, and because any of these programs could be implemented in any of these lands, any development proposal for land that is zoned CI requires special reviews. We, in the Planning and Zoning Department, need to find that the proposal is appropriately scaled, and it is certainly intended to serve the needs of the public as appropriate, but ultimately, our recommendation goes to a public hearing, in this case to the Planning, Zoning, and Appeals Board, so they, with the input of the community, can determine whether or not it is in fact appropriate or find otherwise or impose conditions as warranted. That, in essence, is the reason why not only a heliport, in this particular case, certainly a large-scale proposal and potentially an impactful proposal, but any other use in a civic institutional zone needs a special exception and special review.
Thank you.
Okay. Any, any comments from the board members?
If possible, I would like to address the board.
Mr. Veloso, you're recognized.
I apologize, I was traveling during the last meeting. I think the most important thing before we continue to go down this road is to realize how many years or decades we've been at this without any heliport being operating, on Watson Island. After going through numerous documents, I wanted to get a timeline of certain things that have been impactful to the situation we found ourselves in today. Number one, on October 9th, 2013, Aldo Bustamante, a representative of the Dream Department for the City of Miami, presented all agreements related to the Watson Island Heliport to the City of Miami, Commission, without Mesa's approval. We had no knowledge of the documents that were presented to to the Commission, and the changes that were made, so we never had an opportunity to discuss those or see what was in them. Those agreements included a joint participation for the FDOT grant, which was integrated into all those documents without our approval once again. Secondly, the development agreement, which you'll find in our binders, that needs to be completely discarded. And the reason why is because on June 15th of 2015, the FDOT denied the grant that was supposed to be used for the heliport. That page is in the front of the binder. You'll see a letter there from Gus Pago, District Secretary from FDOT. Third, the interlocal agreement needs to be amended to reflect the current operations of Mesa and allow for its mission. And our mission as a board is to provide grants to those in the community. Fourth, the financial statement needs to be corrected by the end of this week to allow our auditors to finish addressing the financial statement and do their due diligence, and for the executive director to sign it. If that is not corrected, she will not sign the financial statements. And I'm sorry for talking so much. Fifth, and very important, the Watson Island Heliport has not presented to Mesa the requirements per sublease agreement part 2.8.2 to show funding for the construction of the heliport. Because of this, currently it is in default. Six, we couldn't get to this point after many years of asking for information or a certain being withheld information, not following through on the things that we've asked certain departments to do without the hard work of our executive director. She's combed through documents to get us to where we are today. So as a board, before we open it up to questions for those present, we need to discuss how we want to continue this, because none of us, when we first started this, thought it would take so long to get a heliport operating. And what's most frustrating is that I think members of the city in different departments have impeded or have, and I hate to use this word, lied to us and have gotten us to the situation we are in today. Those are my comments.
You, wait, no. Wait. First, would you like to entertain a motion?
I think before I entertain a motion, I mean, I would like to, for the board members to discuss this, to, in case there was any misinterpretation of the comments I made. There's many departments that have come to this room at different times during my many years on the board. And when agreements are put into place without our knowledge and without us reviewing them and sent directly to the commission for approval, that's something that is concerning to me.
Commissioner Gordon.
No, maybe I'd like to hear from staff. I mean, there's some questions being come up in here, and I think staff should be able to answer some of these questions.
Well, I think Board Member Veloso did his homework, and he has raised very, very important issues here. And you know, it's up to the board to move forward on this conversation, entertain a motion, whatever that motion could be. Anybody have any comment in the board?
First, I'd like to
Nathan.
thank Mr. Veloso for that very concise report. Secondly, I think perhaps a way that we should entertain the items you brought up is maybe one by one of those six.
Yep.
Have discussion, and if that discussion leads to a motion, we can actually move forward with some sense of direction.
Go ahead. If anybody else, or if you allow, wait, one second. Let's start, I think it's a good idea. Let's start with,
Well, I mean, the first one that we have to consider, obviously, we've seen a ton of email that we've received, documents that we've reviewed. A lot of these documents are incorrect. A lot of documents are pushed through without us looking at them or approving them. Mr. Rottenberg, who I believe I saw, is a director of DREAM, where Aldo Bustamante works. I don't know if he's been there the entire time that this process has taken place, I believe not. But a lot of the issues concerning the agreements that have been pushed through come from that department, and one of the employees in that department. So I would love for him to speak to us if necessary, but that's the first issue. And to put something that is very concerning to us, as the landlord of Watson Island or the heliport or these entities that take place there, I believe all communication should be directed toward our executive director and members of the board. I believe the biggest issue that has occurred here is that the communication has been directed directly to members of DREAM, the city attorney's office, without our knowledge and without our participation. So if we can't participate in the communications with the tenants and know what's going on, that's where we are in the situation that we're in. Mr. Rottenberg?
Dan, you want to?
Well, first off, Daniel Rotenberg, Department Director of Real Estate and Asset Management. I'm not sure exactly what you're accusing the department of or which documents you're talking about.
Okay.
We can go over them one by one. I think the timeline as to how this occurred is important, not so much for individuals themselves, but as to how Msea has been operating. The time that the executive director, that's currently the executive director, came on board, the availability of the documents, what's in those documents, and their presentation to the city commission as well. If the city commission has voted on them, I guess the city attorney can opine whether or not they're valid. And again, I'm not exactly sure which documents you are referring to specifically, so.
The documents are October 9th, 2013.
But which documents are they?
The interlocal agreement,
And the date on that is 2013?
October 9, 2013. Interlocal agreement, the development agreement, the joint participation agreement, those were all amended in a certain way without our knowledge, presented to the commission in a way that was not corrected. Which wasn't done properly. Those are the three documents that I want to focus on, And that's the date that they were done.
Okay, we can focus on them. I'm not, I wasn't here at that time, but regardless, the process that you think should have been followed is to have brought them to Mesa and have Mesa's board voted on them, and then to have presented to the city commission. Is that correct?
Absolutely.
That is the protocol.
That is
has
protocol.
been the protocol forever, on the Mesa board, is by charter, a state-created agency, that eventually the city commission, this board does not recommend, this board acts. This is a board who has the authority to, act, not as a board that recommends to the city commission.
So how do we go?
I'm just saying this for the record. I understand that you weren't here, and of course, you know.
I don't think
we
the executive
hold-
director of Mesa was here either. I'm a little unclear how we're supposed to move backwards and review this. If that's the case, then they probably should be reviewed and opened up again for review by Mesa and brought back to the commission.
If I could just ask, and again, I'm fairly new here, but looking at the document itself, it says that it is a agreement by and among the City of Miami, Mesa, and Linden Airport Services. So if we didn't vote on it, how can it not be, like, how can it even be valid?
It's not valid.
So I don't know that we have to, whether the question was, I think the term that was used was that they're in default, but, I mean, that seems almost semantics. The agreement seems to not even exist in terms of a legal process. No one seems to be able to prove at all that Mesa had any involvement in this document.
Was there a signature by Mesa on the document?
No.
There was no representative?
So this is the issue, and I think that Mr. Veloso has brought, an important issue, which deals with the power and the mission of Mesa. And I think he has a valid point on, and, you know, the board member is saying it doesn't exist. We first gonna hear the board members, and then we are going to
Could I just,
allow.
just one comment here. There, as to the authority, Miami Sports and Exhibition Authority, there is a signature here by Kirk Menendez, who was the executive director. Either that executive director signed without authority, with a legal instrument, which is a lease and all the documents that follow up, which includes the interlocal. And we do have a very large problem, because these are legal instruments, and the city attorney could opine on that. Or we're gonna have to go back and, I guess, undo what an executive director signed. So I kinda
No.
need direction.
Okay, no, first, we're gonna listen to the board members, and then we'll listen to,
So theoretically, somewhere, there should be, in all good faith for Kirk, some sort of minutes that demonstrate that Mesa did in fact support this. Although we don't seem to be able to find them, but they have to exist. And it was mentioned in the last meeting that we have a lot of stuff in storage somewhere, that no one knows what it is, and it hasn't been properly archived, and maybe now is the time. But we can, there's two ways to go about this, as I understand it. One, whether or not it's valid is one issue, and the second thing, if it is valid, is the tenant in default?
right. Yes, Commissioner.
Well, my understanding is any document, legal document has to go through law department. The law department has to make sure that it goes through the right procedure before it goes through. So I'd like to hear from the law department.
I would encourage that we do not take any hasty votes today. I think we need to look through all the records. I will tell you that for Mr. Menendez to sign on it, for the law department to sign on it, which I signed off on it, all the items had to be in order. The board had to vote on it, or at least allow Mr. Menendez the authority to do and sign. So I unfortunately do not at this time, without further delving into other minutes and the rezos that went before the city commission, I would ask to refrain from any type of vote with regard to that issue, number one.
Okay,
That
the
first one.
only minutes that we have in record from October 15, 2013, Miami Sports and Exhibition of regular board meeting is action item, U.S. Olympic Sailing Team sponsorship, presentation made by Josh Adam, Managing Director of U.S. Olympic Sailing, requesting that Msea sponsor U.S. Sailing for the upcoming ISAF Sailing World Cup in Miami in the amount of $10,000. Commissioner Sarnoff made the motion, Jay Solowski seconded. Board decision, the Msea board approved the item. This is the only minutes that we have on record.
Mr. Chair,
Board meeting.
Yeah, that would be, it probably would have been the minutes from the meeting
Four.
prior. Because if he signed it on the 13th, it would have been with.
There are no
Meetings.
There are no meetings,
There was only 3.
there are no minutes from the meeting, Commissioner.
thank you. I also don't want us to make the mistake to think that the issue had to be decided the meeting before. So many times we decided something, it could be 2 months before, 3 months before a document, especially a legal document, makes its way to being signed. It could be 6 months, you never know. So really, you're looking to the facts of an issue rather than necessarily the minutes. We can review each and every minutes that we have within our possession, and that certainly can help us. But I think you might have to expound upon your search.
I'd like to point out that in 2013, the board meetings of Msea were kind of quarterly. So in 2013, there were only 3 meetings in this room.
Yeah, the minutes were on.
July 17, October 15, and November 16. These are the only meetings that there are in record. And it makes sense because at the time, the Visa board meeting met quarterly. Now, in the last 2 or 3 years, we've met every month because of the situation in the heliport and the seaplane base and the Children's Museum and all that. So, we have any comments from the board members?
I mean, just to get a legal opinion, on this document, on the agreement information, we have Kurt's signature, but we don't have an attested to the signature. Is there a reason why that the legal department can explain to us?
Which document is that?
The agreement information,
Page 30.
page 30?
I don't know. Off the top of my head, I think it's-
No, on top,
No, for Kirk.
up here.
Well, that's Paul Dudley's, but you're talking about Misa's attestation.
I'm sorry, page 20. Yeah,
No,
page
it's
20.
Wrong.
It's the wrong page.
You're talking about the sublease agreement.
The sublease agreement,
That's what Catherine was talking about.
yeah, the sublease agreement.
Which would be 48.
Should there be a signature next to Kurt's in the attestment?
48, I don't know.
Since I feel like I'm somewhat responsible for opening up this can of worms. If,
No.
It's the right kind of worms.
It's the right kind of worm.
but given, the limitations, of what we can determine today, I wonder if it would be appropriate to formally, through
Page 40.
some
Page
means,
40.
determine that we're gonna review this and make sure that this agreement is in fact valid, because there's clearly some question to that. But I don't think we're gonna find the answer to that question today, so that needs to be a priority before the next meeting, is my position at this point. And that, and now, well, since we're all here, and that's not always easy to do, if we can determine, assuming it's valid, pending our next meeting, determine if it's defaulted upon, or it's somehow not valid because of simply the agreement not being fulfilled by all parties.
It's false.
You're correct.
That's false.
We should we should find out, and we should discuss what are the options in case this is not valid. You know, recently, the city commission defaulted Flagstone just because the city commission believed that no work had been done on the site. Yes, we are in court, but the city commission had the authority to default Flagstone Gardens in Watson Island, and this board has the authority to default the heliport and the seaplane base and everything that Msea manages in the Watson Island area. So what you're saying is correct. The board has to consider first what are we gonna do on this matter, and I just wanna ask the city attorney one question. Does the board has the authority to default the heliport contract and the seaplane base, or one, or two, or both?
Is it a question of choice or responsibility, or is it simply, it seems like it's already been done. In the case of Flagstone, I mean, it's empty. In the case of this property, it's also empty. I don't know that's incumbent upon any of us
And that's
to
my
default,
point,
but just to
and that's my
determine.
point, that this board has the authority to default. The city commission defaulted Flagstone because no work had been done within the time frame. So this board has authority to default the parties, any parties because of Commissioner Gray.
No, I understand it. I think we do have the authority to default, but at the same time, I will not vote for default unless I have all the information.
Of course.
I mean, we have an opinion from the individual, did all the research, but we have an opinion. I'd like to hear from the lawyers, from the attorney's office. I mean, I gotta take the advice of the people that work for us. I can't just call default because, all this just come on. I mean, we've been in this for 4 years now. I'd like to hear from our lawyers. So yes, we can declare default, but I will not, unless I have
No,
all
I
the
just wanna
information.
make sure, I
Okay,
just
yeah.
wanna make sure that the board understand
yeah.
that this is not a recommending board, that this is a board that can take action. That's all I wanted to. Madam City
Agreed. This board can take action. However, I would advise you as your attorney not to take any action today until we have all the documents that show that these agreements have been executed properly. We need to get the originals. There is actually one original floating around, which has all the signatures. Unfortunately, sometimes the city copies do not have all the signatures after it's routed. So I would ask that at this time, there is no motion entertained until we're able to research further all the information that Mr. Veloso has provided.
So that's one point we're gonna recognize the attorney for the heliport.
On behalf of Linden, I want to commend the Msea board for having pushed so diligently to get the heliport open. To the new commissioner, when you say it's empty, nothing's been done, I would invite you to go out to the heliport to Watson Island. It's 99%
sir,
done.
please.
It's a heliport,
Forgive
it's
me.
done.
It was a beautiful park that people could actually sit in and access the water because of the property that is now the heliport, not the prior heliport property. And now and regardless of that, decisions were made, but it is by no means done. I was there. I have pictures. I was there last week. I'm sorry, but there's nothing that invites the public to engage with that space in any capacity at this junction.
Well, if my understanding now is that you disagree with the designation of that spot to be a heliport, and you
No.
want to erase 13 years of hard work and dedication.
No,
serves no
listen,
purpose.
if you're gonna debate a board member, we're gonna move on. I'm gonna cut you off.
Well, give me a moment. I'm not
No,
trying
no,
to
no,
debate
no, you're
anybody.
not gonna debate a board
I'm not going to
member.
debate. Let me make some points, okay? After all the hard work of having the staff of the city of Miami do everything they can to move this along, having the heads of all of the departments, it's now my understanding that September 20th is a pivotal moment to get this approved in the normal process. And now, is it my understanding that Msea now is throwing the City of Miami staff under the bus and claiming that they didn't do what they were supposed to? And it seems to me that it's 2017, you want to go back to 2013 and revisit what was done in 2013, and perhaps be in litigation for 10 years, have no heliport open, spend millions of dollars, and have nothing accomplished. I don't think that's anyone's intention, but I think it's good, it's a matter of public record to take that position, that you're going to go back 4 years and claim that the executive director somehow defrauded Msea, and that the
Sir,
City of Miami people
Sir,
are part of some conspiracy.
I cannot allow you to trash the Mesa board.
I'm not trashing, I'm
I
asking.
represent the administration. I represent, as mayor of the city, I do represent the administration. But I represent this board. I was appointed as chairman by the city commission of this board, as well as the other member. The fact that one board member went and did a lot of research, he doesn't get paid. He went and spent hours looking at documents because he was frustrated. It's the same thing that happened with Flagstone Island Garden, that some commissioners did a lot of research and came up with the certainty that it wasn't default. So I would ask you to respect the board. We're not throwing anybody here under the bus. A board member has done research. He has legitimate questions, and he needs answers to those questions. Mr. Priegas, yours.
Thank you very much, Mr. Mayor. Manny Priegas, representing Paul Dudley. I represented Paul Dudley for many, many years, up until the point where his contract was executed. Sorry. Up until the point where his contract was executed and later approved by the City of Miami Commission. So I have a little bit of historical knowledge here. I can attest to you unequivocally, beyond a shadow of a reasonable doubt, that the Mesa board voted for his agreement, for his development agreement. They voted affirmatively for it. As a matter of fact, one of the only members that didn't vote for it was Mr. Kurland, who was there when the vote took place. Okay, so let's be very, very clear and not revisit history, and let's recognize history for what it was. It was voted by this board, it was approved by this board, it went to the City of Miami Commission, and it was approved by the City of Miami Commission. A couple of meetings ago, there was a separate effort by the executive director to call into question whether Mr. Dudley had been in default of his obligations. The legal department did an exhaustive research. Mr. Wysong did an exhaustive research. He came back and he point blank told you all that no, that he could not find anything that demonstrated any default in Mr. Dudley. Now we have a meeting in August. By the way, Mesa board usually doesn't meet in August, but we have a meeting in August where a brand new set of allegations are being thrust upon everyone without any heads up, without any knowledge of what's happening or what's coming, so that folks can't be prepared and folks can't defend themselves properly. Okay? So I say that you follow your city attorney's advice. I think that every single allegation, point by point, that Mr. Veloso has very diligently brought up should be investigated and should be determined one way or the other, just like it was a couple of months ago when the same task was asked of Mr. Wysong and the legal department to do so. And finally, I want to say one thing. All of the decisions that the Mesa board has made, reference to Paul Dudley, reference to Chot, etc., has gone to the City of Miami Commission for final approval. So I put it out there for the record that whatever decision this board might make in the future, whether it be a default or something of that nature, would also have to go to the City of Miami Commission for approval, just like his original contract was and his original development agreement was. So with that, I thank you very much.
Okay, but that doesn't
Let me say something.
That doesn't change the fact that a board member has very legitimate questions and issues. Mr. Veloso, your
I
recommendation.
mean, let's take into account that a fourth of the comments I said are wrong. The fifth comment, which is the sublease agreement, states that there has to be proof of funds, $350,000. It's sublease agreement part 2.8.2, proof of funding for construction. We have not received proof of funding for construction.
May Mr. Dudley answer that
Yes.
point? Would you mind if I pass the microphone along to Mr. Dudley?
Yeah, go ahead.
Thank you very much.
Good morning, board members. Paul Dudley from the heliport. Well, I'm a little stunned at this. The problem is that this project has gone on for quite a long time. And I would like to state up front, it is from no fault of my own, nor for a lot of people in this room is it their fault. It's the result of lawsuits by outside parties. There was 8 years, I believe, just with Chalks alone. There was many factors which we have no control, nor did the city have control. There was confusion with the zoning, where we were told to take a path, and we made the applications, and down the road, we were told that we had to completely discard what we did and start again, which we have done. We're on for September 20th. Looking at the historical stuff, I do not know why there are missing Msea minutes. I don't know. But I can tell you that I've been in this process since 1998. And in 2002, the board voted to accept our proposal. There was years litigation, and then for almost 4.5 years, the state of Florida took the property for the construction of the tunnel, and we were unable to do anything. They didn't get off the property until 2014. I think it was August. We couldn't even get on it. Now, all those years, there was a gentleman, there were several other executive directors. One was Tim Schmond, a lovely man, and one or two others, I believe. I think Kirk was in there too. I was in this room when this board voted for these contracts. So to say the Msea board didn't vote on them is just inaccurate. And because you can't find minutes, which we're not responsible to keep, doesn't mean it didn't happen. Secondly, during those years, virtually all of the commissioners took the time to come here and sit at this board. So the same people that were sitting on that dais down in the room over there in the commission hall were sitting at this meeting and were well involved in this. The board also charged Mr. Schmond with the negotiation of the contract in cooperation with, at the time, the real estate folks in City Hall, which Aldo Bustamante was one. I think before him it was Laurie Bilberry. So to suggest things did not happen appropriately is rewriting history. This board was well involved in it at the time. The director, and I'm sure if necessary we can get them involved. We don't want this to explode into a lawsuit because we're at the 1 yard line. We're at the 1 yard line. We are finally at the point that once we get our zoning correction, our warrant done, we're then moving forward to get a license. We don't want this to get delayed any more than it is. And I understand your concerns. Now, there was an email which came from Mr. Bustamante. And unfortunately, I didn't know. I thought this matter had been settled because we discussed this previously. That stated that the required information had been provided. And there was a whole big kerfluffle at the time because Ms. Blanco sent me a letter telling me we were in default for not providing it. But attached to that email was the statement from Mr. Bustamante saying we had provided it. Clearly we did. The thing is built. Now, I understand that some people have ideas. Maybe you thought it should be a park, and I got that. But to say nothing has been done, I'm the only person that's built anything. I don't want to be tarred with the same brush as Flagstone. I've built it. It's done. It's been fenced. It's been graded. It's been paved. It's been marked. We were ready last September to open. We even have it insured as a heliport because we were so sure it was ready to open. In June of last year, we filed for a warrant because we were told to file for a warrant. A warrant was supposed to take 3 months. This was supposed to cure the zoning issue and allow us to operate. That was in June. July, August, September. 3 months.
Mr. Dudley, can I
That's not the
interrupt
question.
you?
I'm sorry?
Can I interrupt you something because
Yes,
Executive Director needs to clarify something.
Yes, Mr. Dolly, how are you? You just said, sorry to hear that. I just would like to clarify that I never sent you a default letter for what you just said. It was sent because of the lack of insurance. And it was a misunderstanding between Mr. Wisen and you because you kept sending him the information, and I was provided with the insurance policy almost 4 months later, or 6 months later. So this is the only time that I've sent you that.
Okay, well, I have
It's in
other letters,
reference-
and I'll be happy to send you copies. What I'm trying to drive home
Okay,
here
can
is
you please
we have
clarify-
provided it.
Yes. Yes.
I think the question had to do with finance.
Finance it. I mean,
We provided it. We have
Right, but it was
provided
never
it.
sent as a default, so you know.
You send me a letter, we provided the information, and
That-
you have a
that is
letter
correct.
from Mr. Bustamante
That is
saying the
correct.
city received it.
is correct.
And it's built. For God's sakes, the thing is built. We have done everything we're supposed to do. The law department, at your request, reviewed everything 2 meetings ago and gave this board a determination. We are not in default. I've done everything I could to move this thing along. I've stuck this thing out since 1998, for God's sakes. Do you honestly think I'm not trying to move it along? We pay you rent every month. We pay almost $6,000 a month in rent. I pay property taxes. I pay insurances. I pay maintenance. I've paid the hundreds of thousands of dollars to build the heliport. So to suggest that we are somehow not performing is just a misstatement. It's not true. So
Well,
without
if
getting
I
any
may-
further, to
if I
answer it,
may,
we
just to
have given you what you
clarify-
asked for.
If I may, just to clarify the record, the Mesa board gave you a grant to help with the underground of the wiring and.
Well, that's incorrect, Mayor, and I apologize, but if I may explain, we've heard this before. This is the second time this has come up. That's not what happened. We are obligated to move the utility lines. That was originally the original highway, the original MacArthur Causeway, when from 1907 or whatever it was. And they ran utility and water lines right down the middle of it like they would do any street. When they relocated the new highway for the Trooper Smith Bridge, God rest him, they abandoned that portion. But the utility wires were on poles going down the middle. Our contract requires us to relocate the wires. That was about a $50,000 item for us to relocate the wires around the perimeter on poles. That's all we were required to do. It was the attorney before Mr. Wysong, Raphael, and this stood in that spot, read it to this board, and said that's all we're required to do. It was Councilman, used to sit here, starts with an S. Can't think of his name. Councilman, Commissioner Sarnoff, who sat in this chair, said, well, we want to put it underground. We don't want it to go across. Well, that's almost $350,000. That's not my obligation. The board said, well, how about, actually, he said, why don't we put up $200,000? Will you put up the rest? So instead of me spending $50,000 to move the wires around, I had to spend $150,000 of my money, plus the $200,000 that was proposed to be contributed by the Mesa board. This was not a grant. This was money that is being paid back out of the restricted account. The money that we pay into Mesa goes into a restricted account. It's supposed to be spent on the heliport. So there was no grant, and this has been misunderstood. It's a very common misunderstanding. It wasn't a grant. This was an item that I spent $100,000 more than I had to spend to accommodate the board. So between the $200,000 they kicked in, the $150,000 I kicked in, those wires got put underground. So to suggest that somehow I'm not cooperative, I put my money up to do this. And it's not costing Mesa anything, because all the money that we pay in comes back, and I believe that might be close to being a zero number right now. So please understand,
if
I've
I-
done everything that I can do.
If I may
Okay.
ask one brief question
Okay.
to clarify, as well, and to Manny's point, it is fine that it is not a park. It is not fine to me as a member of this board that it is not publicly accessible or has no public use. I understand that you've worked very hard to make that so. I understand everyone in this board is making it very hard to make it so. It seems we're at an impasse here because the agreement that allows you to continue working so hard is contingent upon money from FDOT that has been quite directly denied. So I'm trying to understand, you say that the finances, that you've stuffed them in some other way. So clearly, the agreement needs to be amended to demonstrate where those funds are gonna come from and how. So that's the question.
All right, we can answer that this
Can
way.
I,
That
can
was an
I do
option.
something? Can I, Ms. Moore, can I do something? Commissioner Gore has some clarification, but we have the auditor, we have Mr. Pedro de Armas, the new auditor, which, by the way, it's the person that was hired by this board to do the audits, and he may give us an idea of what Ms. Moore is saying about the grant, the FDOT grant that never happened. Would it be possible for you, Mr. De Armas, to address the board? Give me the microphone, please.
Good afternoon. The issue being,
Your name and
my name is Pedro M. de Armas, and I'm a partner with the firm Verdeja de Armas en Trujillo. Good afternoon, all. The issue relating to financial statements is the fiscal year end of Msea is September 30th. The audit period that we're talking about is September 30th, 2017. So therefore, any issues regarding a grant agreement, which was mentioned earlier, or agreements should be finalized by then, or if they're not finalized, we can have a subsequent event stating the progress or the status of any type of agreement.
So what you're saying is that the grant that we never got should not appear, and it's not part of the audit.
Well, I don't have privy to any of those work papers or details of those grants, so we're talking hypothetical. But what I'm saying is, if an event or agreement is amended and changed, or the terms, existing terms as of September 30th, which is a cutoff date, then the reflected notes on the financial statements should be as of that date. Now, if an agreement or amendment or change or anything related to the financials aren't finalized by the end of the fiscal year, we have what is called a subsequent period until we release the audit report date. We have subsequent events that we should address if it gets amended or changed after that period. So you have some time to get information into the financial statements, whether it's by the end of the fiscal year or after the fiscal year before the report is issued. So it's just a window.
Commissioner Gore,
My understanding is, we discussed this in the last meeting about the grant, and it was the opinion of the law department that if the grant was not accepted, it didn't have to be reported. It's my understanding. My understanding also, we asked one of the board members, Eli Feinberg, together with her to work and come up with the right wording for this. If it's the law department is correct, or the administration is correct, and so there was supposed to have been a meeting, and something's supposed to have taken place. I don't know if that took place or not. Answering this thing here.
I can address that. The meeting did not occur because. Hold on, George. I want to make sure it's on the record. Thank you. I can address that. George Weissong, Assistant City Attorney. The meeting did not occur because we hadn't finalized the agreement with the auditor. So now that he's on board, we can accomplish that meeting. And just to clarify, the issue was, we just wanted to ask the auditor a question, which was,
you know, the whole issue of the restricted funds. And the funds were restricted because the documents reflect an FDOT grant. And there was subsequent documentation indicating that there is no FDOT grant. The city never took possession of any FDOT monies. So in light of that information, would those documents be sufficient work papers to show that there is no FDOT grant and therefore there's no need to restrict the funds? And that was sort of the issue. We're not saying that they need to be or they don't need to be. We just wanted to clarify that point with the independent auditor or the external auditor. So that's where we're at. And so now we'll set up the meeting now that this fine gentleman is on
So
board.
what you're saying is that with the new auditor on board, the funds are not restricted.
Well, I mean, ultimately, that's a financial decision that we'll have to work out. We don't know. That's what we want to ask and discuss.
Yeah, I'm sorry, Mr. Dermas, we couldn't speak too much previously to you coming here, but we did discuss some of the agreements, and I did inform you about having an issue with Rishi Tandok, previous auditor, and the way he wrote, and I think that he did correctly. He's supposed to write everything in conjunction with the numbers that you put together. And I want to read for the record what the financial statements say, and this is what I need to be corrected, because then we need to take away all the restrictions. There's a joint participation agreement that is integrated in all the documents, which is expired on June 30th, 2016. Also, the grant was denied on June 15th, 2015. And that puts together the whole puzzle, because whatever we do, it needs to be accounted. So this is what it says. In conjunction with the Linden sublease agreement, Linden entered into a separate development agreement with the authority and the city for the construction of the helipad, to be paid by a $350,000 contribution from Linden, and the remaining construction costs to be paid by the city through the grant funds. So this is what the board is asking you. When you do the audit, if there is no grant, we need to take that away from there, correct? Okay, then now that trickles into the sublease agreement, because as 2.82 says, Linden should have presented proof of funding for the construction of the heliport. So my concern is to have the financial statement with the current operations of Msea as it is today, not as it was in 1997 or as it was amended in October 9, 2013. What I need to have is clear financial statements as we have the operations today, which the documents as of they are today do not reflect that.
Mr. Derama, you want to comment on that, or?
I think part of our audit process and due diligence and testing would be to test the terms, the validity, the existence of all the documents. The good and bad thing about changing auditors, it's a new set of eyes. So we will look at all those things as if it was, and it is, for the first time. And we'll be asking questions. Sometimes it's going to be repetitive of your executive staff and maybe even, the board members regarding those documents and issues. So that will be part of what we do in relation to the audit.
So is it possible to have everything resolved on time before the timeline expire for the audit to be signed?
So there's two timelines. The first one being the end of the reporting period, which is September 30th. And then the following timeline is the time up until the report is issued. So you have 2 dates. So depending on the rules and when your financial statements are required to be issued, you will have those 2 kind of finish lines to deal with, or reporting deadlines to deal with.
Okay, okay. And it's, George wanted to say something, or if we...
I just wanted to comment. I've heard a lot about paragraph 2.8, and those of you that have the sublease agreement, the language is on page 8. And you just have to carefully read the language. It says 2.8, conditions precedent, that means before. Condition subsequent, that means after, right to terminate. This sublease is subject to the following conditions. 2.8.2, conditions precedent to sublease. Tenant agrees that this sublease shall be automatically terminated in the event that within 12 months after the effective date. So we know the effective date by virtue of the clerk's certification is October of 2013. So within 12 months after 2013, the tenant shall not have provided to the authority, A, satisfactory evidence that sufficient funds have been or will be secured by the tenant for the construction of the heliport, which evidence may consist of approved grants, loan commitments, letters confirming individual and/or corporate donations or sponsorship. So it was a year after the effective date that that information was required. We're not talking about now, we're talking about from 2013 to 2014. And what I would ask is, are there any records from 2013 to 2014 from the executive director that show that those documents were not provided? The tenant has indicated that they have been provided, and the only response we've heard is that the record keeping of the previous executive director was not the greatest, so therefore there's no ability to show that that condition wasn't met.
Okay.
So I just wanted to clarify that that condition is from 2014.
And that is the fundamental issue here, because the executive director that we have now wasn't here.
Right.
The city attorney that we have now wasn't here. I wonder if the city attorney that was here, I think it was Rafael, had historical memory or kept notes, but I do think that the executive director has some
Yes.
It was,
information
Okay.
here.
It was Veronica Diaz was
Yeah.
the.
It was Veronica.
Yeah, Mr. Wisen.
It was Veronica, so we need to bring a judge.
No, a judge, yeah.
Uh,
We could believe her.
Mr. Wisen, just in reference to sublease agreement 2.8.2. Okay, yes, we did discuss that many times, and you provided me with a letter dated August 1st, 2016, that you received from Lyndon, and it was given to me very recently in a meeting that we had, and I said, you know, it's a little late, but then again, we discussed it, and it's like a spreadsheet of the expenses without receipts that up to today, supposedly, Lyndon has spent in the heliport. And it is $431,271.80. Now, what I'm referring to is the rest of 2.8.2, where it says the rest of the funds are going to be constructed with funds, loan commitments. We need to have proof. How is the heliport going to be constructed? Which funds? Which funds do we have to finish that heliport? That's my concern.
In that list of, in that paragraph on 2.8.2.
Yes.
It gives examples. And the very last example says,
Yes.
and/or corporate donations
yes,
or
sure.
sponsorships.
Yes, but-
So that means in that interpretation, any of these things can apply. It could be a grant.
Right, where is the money?
It could be a loan commitment.
But where is the
It
money?
could be a letter confirming individual and/or
Right, I don't have proof of how that heliport is gonna be constructed.
But do you have proof, do you have records from 2013 to 2014?
This is all I have, what I read to you.
When
This
that proof was required?
This is what you said. This is part of the 350,000. Actually, Lyndon according to this, Lyndon has spent more than the 350,000 that
So
is
that
required.
should be proof in and of
No,
itself that he's capable of
what is,
building it if he
no,
spent
I'm not referring to that.
$400,000 to
No,
build
but
it.
I'm not referring to that. I'm referring to the other part that the FDOT grant was supposed to have covered.
There is no FDOT grant.
That's what I'm saying. Then there's no
And-
monies.
And on numerous occasions, I think the last meeting, Mr. Dudley has indicated that he has the ability to pay for this.
Wow, that's another,
And,
I
and
didn't
in fact, he
hear that
was,
before.
he was put on
So-
point, I believe, at the
Right.
last meeting. Does he have the capability to pay for this? And how's he going to pay for it? And he said he's going to pay for it.
So we just,
So the issue is, I just simply wanted to say that the time for the default on 2.82 has passed as of 2014.
okay, Mr. Veloso, do you have any other issue? Because,
No, honestly, and let's move forward. I asked a pretty specific question. To my knowledge, it wasn't answered. Mr. Wisen is telling us that that opportunity has passed. If the money is not here now, I don't think it would have been there in 2013 or 14, but those 12 months have gone by, so we can't go backwards, according to what you're saying.
Well, you could ask him to show you proof that, well, right now, it's a tri-phase agreement. It's the squares on the ground. Then second phase is the fuel farm, and then the third phase is the much larger facility. I don't think it inappropriate for you to ask him when he gets to phase 3, do you have the capability of building this? I think it's a little late to ask in phase 1 and phase 2, do you have the capability of building this? Because for all intents and purposes, it's built. I mean, all they're waiting for is the zoning approvals. So, but what I'm saying is, I don't think you can default now on a condition precedent that said you had to do this within the first year of the agreement.
Understood.
Okay.
Misa should have acted then.
It seems that the law department is being very diplomatic in terms of this situation, but there are questions that needs to be answered. So you want to be
Yeah.
recognized?
Mr. Eisen, this is my concern. The FDOT grant was supposed to be for phase 2 and phase 3.
There is
That's
no
according,
FDOT grant.
according to the joint
Oh, everybody
participation
knows that
agreement.
there is no-
Yes, but of course, there's no, that's what I'm saying. If there was, then we wouldn't have this conversation. The reason that I'm saying is because phase 2, phase 3 was supposed to be covered by the grant that doesn't exist.
Well, I would ask you to show me in the sublease agreement where it requires the heliport to use FDOT grant funding to construct the
No.
heliport. It's not a
We're
requirement.
not talking about that. Yes.
So
No,
look,
we're
if
not talking about
if
that.
I understand correctly, you want to see at least or something to the tune of $350,000 before we proceed with phase 2 and 3. Is that what you're asking?
No,
Or-
Mr. Madison, according to a spreadsheet that I don't have any documents to prove, they have already spent over the 350,000, according to a document that Mr. Wisen provided me. What I'm concerned about is the rest of the construction.
Okay.
How
If
is
they
it?
have the funding
Exact-
to
Okay.
do the rest of
And
the
so with
construction.
that, I don't have any, I know you have the spreadsheet. We don't have proof of that. I don't have any doubt that that amount was spent on what's been
No,
done.
I'm saying
think
I
that-
don't have any receipts.
I think, Dave, I think that what he's asking and Mr. Veloso is asking is that the board needs some kind of proof. Mr. Wison said, he said it, that he has the money to proceed with the whole construction. So if the board wants to create a resolution directing Mr. Dudley to,
So for a financial
show-
review.
So to come up with a definite answer to the question, do you have the funding? Where is the funding for step 2 and 3 or 3 and 4? Is that something that the board would entertain, Commissioner Good?
Oh, I'd like to see all the questions that he has. I think that he believes them to be very valid questions. They should be answered. But I think they should be answered by the different department and come up with it in the next board meeting. I don't think I personally am not ready to take a decision here today with what I'm hearing back and forth. I'm hearing a lot of back and forth, which is,
I mean, the motion that I think we should pass is that our executive director needs to meet with Mr. Rottenberg from the Dream Department to go over the allegations with regard to all the agreements. That is number one. Number two, all the documents need to be corrected with, after that information process is taking place, the financial statements with our new auditors, along with the attorney's office, also need to be corrected to show the proper numbers in our Msea accounts, which will take out the restrictions that are currently in place and allow us to provide what our mission is.
Okay, we have a motion. We got everybody.
Second.
Okay, we have a motion and a second. Any comment? All in favor, say aye.
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 It needs to be done before the next meeting, which should be in 30 days.
Okay.
30 days.
Do you have to vote again on that, or?
Added to that motion, it needs to be done within the next 30 days. Adding to that.
So we need to vote again. All in favor, say aye. Aye. Motion amended, 30 days. Are we okay with that, Dan? Are we okay with that?
And can someone taking these notes re-enumerate for me exactly what is gonna come in the next 30 days?
Okay.
I'm sorry, I can't.
The proof
I was
of
asked a
financial-
question. Let me
That's what I don't
ask
know.
a question in return. You're making a statement or allegations, as you say. I need a list of those allegations just handed
Yes,
to me.
of
I will go through them with the executive
You will
director,
get
no
it-
problem.
You will get it tomorrow, but could you repeat for Ms. Moore
The three things that we're gonna take a look at with the executive director and Mr. Rottenberg is the interlocal agreements, the development agreement, the joint participation agreement, all which we question to be
Right.
valid. That's number one. Number two, we also have to look at the financial records of Mesa, and certain restrictions are in place because of the grant.
Right.
If those are taken out, it allows our accounts to be unrestricted and used for the purpose of our mission.
I would also,
Yes.
I would
yeah.
like to motion to see if we can have the proof of financials by the next board meeting. Then it can provide proof of financials to provide the next step in step 3.
Nathan,
For the last 3 years,
He's been
I
asking.
have made a motion
He's been asking for it.
requiring
Yes.
that both the heliport and Chalks turn into us a set of audited financials. That has been completely ignored as if it were requested as opposed to being required. And it just goes off into a vacuum. We already have on the books a request for a set of audited financials. That will actually
Okay.
tell us whether or not both groups have the money to finance what they need to finance.
Okay, Madam City Attorney. Does the board has the authority to, again,
Yes, you
pass a resolution? What are the consequences if within a certain period, 30 days, this board, through the executive director, does not receive those statements?
Well, I need to look at the at the agreement to see if there's anything with regard to audited financial statements and any timelines on that, but obviously, it, you know, we can receive them. I just don't know if we can default them for not giving this,
Through the chair.
you know.
Yes, yes, sir.
If I remember correctly, we had this question come about when we were looking at the lease agreement. I can't remember exactly what the reading of it was. I'm sure some of the representatives of the organizations can. But there was a question as to what the lease agreement required. And I think there was a disagreement between whether or not it was audited financial statements, which are something that is much more formidable, much more informative, versus basic financing documents or accounting of the odds and ends, if you will, of the organization. If I remember correctly, and sometimes I do not, it was the latter, not the former. And so I think that's part of what the hang-up was with this moving forward. No one's going to want to give us any information they're not required to give us. And so that's the question. And I think if we ask ourselves, do we have the authority to demand them? We're probably on the negative side of that, considering the lease agreement that we're in with them.
Are we not within the authority to ask for at least what is in 2.8.2? And that's all I want to
But
see.
the-
I mean,
It's
it'd
moot.
be great to see.
2.8.2 is moot. It's a non-issue because
Not in
it's,
regards to defaulting, but simply in regards to, we are allowed to have these things. According to this document, why can we not request them now? Maybe we cannot tell them the agreement is void if they don't have it anymore, but it's fair that they need to provide a commercially reasonable business plan, an aeronautical license. We have not seen a copy of their aeronautical license. We have not seen this reasonable business plan, and we have not seen satisfactory evidence that sufficient funds have been allocated for this. That's all I want to see. I don't want to. I'm not trying to make it impossible.
You can definitely ask for audited financial statements the same way that our independent auditor can audit any lease within the city of Miami and Mesa and those So obviously we can ask for them. I think that we were having trouble finding out which statements we want to ask for, and I think you articulated it correctly, Commissioner Hardiman.
Yeah, you want, Dave?
Yeah, I think from my memory, there was some hesitation from both parties to submit those statements, but I do remember them agreeing to sit down with whoever was designated for a review, but not to submit their private books or businesses' financials to the board for open review to the public. And
Fair enough.
Okay,
Fair enough.
okay,
So-
okay, okay,
Are we within our rights to ask for all the documents that are established in 2.82? Can we ask for them again? Is there anything in the lease that says that we're only allowed to ask for them once and we're never allowed to request them again?
Rudy had a motion. Would you repeat the motion? Would you participate and modify the motion? And then-
Potentially?
Yeah, sure.
Friendly amendment.
For a request within a 30-day period to provide the audited financials to ensure that the Linden can go ahead and Chalk can go ahead with their, construction.
If I could amend that and say, he's basically asking for 2.8.2A, I would like to request within the next 30 days, 2.8.2A, B, and C. I would like all of them. I would also like to review the commercially reasonable business plan. I don't need to see your full financials. I'm disinclined, but I do need to see what is outlined here. I don't care in what form they are.
Yeah.
Once you have established you have sufficient funds, everything else is irrelevant to me. So that's all I want. I'd like a commercially reasonable business plan, and I'd like the copy of the aeronautical license.
Okay, would you agree with the amendment?
Absolutely.
Nathan,
Yes, sir.
Pardon?
you want to amend, is that okay with you?
That's fine with me.
Okay, we have a motion, and we have a second,
I just needed to clarify something. You asked for the aeronautical license.
See, there's two.
You all know tortuously that we're in the process of getting the aeronautical license.
but that doesn't
so
matter.
We don't have an
She just-
aeronautical
she
license.
wants-
I know.
she wants
But
to
I didn't want that to be
understand-
part of the motion that Dudley
No,
has to
it's part
provide
of the
the
motion.
aeronautical license.
So it's everything that you guys have.
Okay, so that's a separate question I have. So I will
Wait,
re-amend that
let-
motion
let-
to just be A and B, because frankly, if it says here, if there has to be an aeronautical license within a year, I don't understand.
But this is where I urge caution. Read that 2.8.1.
That's why they get it.
Who's responsible for it?
I don't share your caution as I work on
The
behalf of
city
Msea.
shall obtain an aeronautical
So,
license.
forgive me.
So you
If-
should be asking the city for the aeronautical
Okay,
license.
then I will
But-
ask the city instead.
But we have put the burden on the tenant, Linden, to obtain the aeronautical license.
According to C, it says here, that the tenant shall, if necessary, obtain said aeronautical license, or no, just remove all
Shall
obstructions.
remove all
as-
obstructions. Yeah, you gotta
Has
read
he
the whole
done so?
sentence. The obstructions are the power lines, I believe.
So then it should be fairly easy for you to comply with C on the amended resolution. You should be able to supply C. C is proof that you have removed all obstructions as required so that the city can obtain the aeronautical license. That's it. That's what I'm asking
They
for.
paid the bill, so the executive director would have that record.
Okay, but first, let's,
don't have that
wait a minute, wait a minute. Let's vote on the motion, the amendment motion. Commissioner, you wanna, anything?
Many of those documents that be presented, all you need is a copy of the documents that are being presented. That should be, that's
Exactly.
why they gotta check on, that's it.
Okay, so we have a motion.
Call the
This is,
question.
this is 30 days. You wanna-
I wanted to make a comment. I mean, before we vote on the motion, which I don't see why Linden wouldn't want to, agree to it. As Msea, we want to get it done. Linden wants to get it done. We're going back and forth. If I feel like I'm in the middle
called-
of
it's
a
called the
huge
Twilight Zone.
lawsuit, where we all have the same common goal that we want to get it done. I understand with the 2.82 that's been referenced back and forth, if it was up to 2014, where we would have had the legal right, according to our council, whatnot, to default them on it, then shouldn't it be in our records or in the records that proof before the 2014, while we would have had that right. If Linden complied with that and they had it, then can we see that? Is that something that we can see? That we can see how they had complied to the 2.82 within the year that it was required? And then now, moving forward with the motion, I'm in agreement with the motion of everything that's going on. I think Linden should too, and let's get it on the record and within 30 days, because if not in 30 days, when we come back here, we're gonna be in the same, saying, oh, let's request it. We can keep requesting every time and pass the motions, but unless we're gonna really comply in what it is, and if our legal staff needs to look into what are the consequences or what it can't be, we're gonna make agreements and we all have to own up to it, both on the Msea side, on the city administration side, and on the Linden side.
Okay, so we have a motion. I just want to understand from the city attorney. If this motion is not complied with in the next 30 days, on the next available meeting of Msea, what is the remedy or the consequences that this board can impose?
We will let you know what are the remedies, or the the consequences.
Okay.
So again, the resolution would be that we would ask the tenant for these items, whatever proof you may have. In addition, we would like to ask the city attorney's office to clarify as soon as possible and at least within 30 days, but ideally as soon as possible, to let Lourdes know, who can then forward it to us, what exactly would be the ramifications, and frankly, I'd like an assessment of what power do we actually have in maintaining this lease, if not this? If we can't ask for basic, simple conditions precedent to sublease proof of them, then what power do we have as landlords? I have much greater rights as a landlord in the state of Florida than I appear to have on the Msea board.
That's why I have to check the lease agreement
So
and
please
see
let
if
us
we're
know.
complying with the lease agreement.
Thank you.
That's fine.
And thank you, Mr. Dudley.
Okay, all in favor say aye.
Aye.
The executive director wants to
Yes,
clarify something.
Yes, I would like to say that, Mr. Wisen, so then all the agreements will be amended, correct?
Based on
Based on
the
the
grants
grant.
and
Yes.
we still need to meet with the auditors, make sure and find out what monies, if necessary, need to be addressed, and it may not need to be an amendment. It may not have to. So we're
Okay,
not there
Let me
yet.
leave in the record that the FDOT grant is expired. And there is an in the interlocal agreement, there is a joint participation agreement expired as of June 30th, 2016. Mr. De Armas is here. And this is something he's gonna have to look at. The FDOT grant was denied June 15th, 2015. Now, the accounts right now are restrictive. So I am asking for the board to give me permission while we do that to close the accounts, the Chalks and the Linden, and put all the money into Mesa's general fund account, because that's what they should be. They should not be restrictive. All the accounts are restrictive, and we should not.
Understood.
So I would like to get the permission of the board to close these two accounts and to place the monies into the Msea general fund where they should be.
Before that's done, I think we need to speak with the auditors, as we discussed,
Yeah.
and but we're not gonna put them on the spot right now.
Okay.
It just doesn't work
You
like
don't
that,
wanna do
Lourdes.
that to the poor
So,
guy. Guy just walked in, you're gonna put him in that spot.
right, we have to let him look at all the records,
Right.
Okay,
we'll
how
consult,
long-
which was the
how
last
long,
motion last time.
I'm sorry, but I think, as per my prior conversations with Lourdes, the conflict is in this document, in the sublease agreement, it says, y'all have to prove that you have the money. But there are 3 documents that involve our contractual relationship. In the joint agreement, it stipulates that the money has to come from FDOT. It doesn't stipulate you have to have the money. It stipulates it has to come from FDOT. That's the problem.
That's the
What we
problem.
need to amend is not this, because this is fine. But if the joint agreement, which is equally important, I think,
What do you mean by joint agreement?
There's 3 documents that refer to this relationship. There's the sublease, there's the interlocal, and there's the joint agreement.
The development agreement?
Yes. The joint agreement says,
Well, the joint agreement, the JPA, was an attachment to the development agreement, and it doesn't exist. There is no joint
That's why we need to take it out.
participation agreement.
That's why we need to remove it,
why do we have to remove it if it doesn't exist?
because it's integrated in the documents, and the auditor's gonna cash it, just like the same, like what happened before.
Okay, this is a separate issue, I guess, but, can I ask the city attorney to clarify to us how this document, which I have a copy of on my computer but not in front of me at the moment, doesn't exist? And can we just get some clarification that FDOT is explicitly not involved in anything that has to do with Linden? Because that should hopefully support your issue regarding the accounting and whatever else.
Financials, that's what I care for.
But even if there's not an issue with accounting, I would just like to know that agreements that have been provided to me as a board member exist or not.
So it's probably longer than this board meeting can entail, but you just sort of have to look at the history. In 2012, when these agreements went to the city commission, the resolutions talk about the city developing there's many names for the facility, but it was going to be one big airport facility, and they were going to use FDOT funds. And in consideration of doing that, they were going to get a joint participation agreement, grant funds, and all that. And so, but that never actually happened. And so that doesn't mean that, so the interlocal agreement did 2 things. One, it allowed the city to grant the real estate to Msea to then sublease to both the seaplane base and to the heliport. So that part of the interlocal agreement is the most relevant part. The rest of the interlocal agreement talks about if this stuff is built via FDOT funding, then you have to enter into a JPA, a joint participation agreement. You have to do all this other stuff. But see, that's been the confusion, is that in light of the fact that the city never received $1 from Florida Department of Transportation, there is no joint participation agreement. It didn't come to fruition. There's a document, but it never came to fruition. So therefore, we are under those agreements, but without the grant and the joint participation agreement.
Okay.
That makes sense.
That provides some clarity. Thank you.
Okay.
It does not resolve the issue of where there's all this manic concern about our financials, but hopefully that will be resolved within the next 30 days.
So we did vote for the 10th time asking for a financial statement. Hopefully, the city attorney's office will provide this board with the information of what is the remedy or what are the consequences if what the board is asking is not provided in the next 30 days. The other issue that we had on the agenda is the discussion about financial statement correction and moving forward. And I think that has been discussed with the new auditor. Is that, Mr. Auditor, do you have a timeline? Do you want to say something to the board in terms of?
As far as what specific timeline?
Well, you mentioned September 30th. We all know that we never got the grant from FDOT. Like Ms. Moore said, we need to understand that FDOT, according to the secretary, is not going to get the grant. So this has to be taken off the documents.
So then there's another issue from what you're mentioning, where there are a set of financial statements already issued, if they have been, from your prior auditor, effective for the fiscal year September 30th, 2016, that are incorrect or that should be restated based on the information that you're describing. So if there's an issue that, again, is disclosed in your financial statements that are incorrect today, but they affect the September 30, 2016, it's up to the board to consider reissuing that if they think that anyone is relying on that information as well.
Okay,
No, we should make a motion to correct the incorrect
okay.
financial statements, get those corrected.
And then give the direction to the auditor,
Exactly. Perfect.
okay?
Okay.
You wanna do it?
We don't know if they're incorrect yet.
No, that's the motion. It's incorrect because the grant is never there. So we have a motion.
The lawyer has a different opinion, and they're the one that work for us.
Yeah, I know.
Are we becoming lawyers? I mean, I want
No,
to
no.
make sure.
We had a very, we talked about this ad nauseum last time, which is we were going to meet with the auditors. We were going to see what was going to be the opinion of the auditors. We'll make whatever corrections are needed so that Lourdes is comfortable signing whatever she needs to sign. And then we would determine what, if any, agreements needed to be amended, if any, because some of these things are practical impossibilities because they just have not happened. So all of that will be done as soon as we talk to the auditors. We have them on board now, and we can go from there. And everything will be resolved. Lourdes, you will not have to sign anything that you are not comfortable with.
Perfect, thank you.
Okay?
Okay.
Okay, sounds good.
Sounds almost like we're done.
However, you know, we just need to understand that this board, if we get some information, has the authority to default any of the contracts.
Yes.
And that's we understand that.
You are the landlord.
Could you restate that again? We have under what?
That
We have the power to default.
we have
If they're not in
the
compliance with the
power,
contract.
this board has the power to default.
Of course.
And I don't think, and I don't think that default has to go to the city commission to be approved.
That seems fair, but the definition of what those conditions are is what remains unclear.
Right. But,
I'd like to know exactly what those conditions are, and that's what I was asking for the legal department.
That's what we're supposed to get within the next 30 days.
So that we will have some answers on our next Mesa meeting, as opposed to just
We have
walking
to,
out with
because
questions.
it's getting too
yeah, yeah.
My patience is a virtue, I'll ask, don't worry.
So board members will be notified of
Thank
the
you,
next
gentlemen.
meeting.
Lourdes?